Hi, y'all, and welcome to today's live stream. Well, I took a few days off after we had our coverage of the Donna Adelson trial, but clearly Donna Adelson's team did not because she has already asked for a brand new trial. She's done that, and specifically today, what I want to talk about is she has suggested that the jurors may have engaged in juror misconduct and that might entitle her to a new trial. She wants to interview them. Is she right? Or is this just one last desperate attempt to avoid justice? As we know, Adelson is accused of murdering Dan Markel. He was her ex son in law, and her son already serving life in prison. And now Donna has been convicted as well. So today we're going to be diving into Donna's brand new motion. She says she thinks there may have been juror misconduct, and she wants to interview two of the jurors specifically to talk to them about what exactly they may have done, what may have happened during the jury deliberations. So I am so glad to be back with you. I thought we would play a little game of Clue for those of you who don't know where I was, which for some of you, you probably already know. But I thought I would do some little hints and see if you can figure out where I was. So that's my daughter, Anna. The are somewhere in the world, but I'm not going to tell you where. If you already know, don't tell everybody. Hold back on that for those of you who already know. All right, so that was your first clue. We'll pull that out and let's get started talking about the case. I want to say a special shout out to the first five in today's chat. I know we're at an unusual time, so I am glad to have all of you with me. If you would please hit the like, that will help YouTube and all of our fellow members and fellow subscribers know that we're live and that we're ready. So the first five: Villanelle's Boots, Bama Queen, Bonnie, Betsy Sue, just call me Betsy, and Carolina Lady. So glad to have all of you here today, and a special welcome to the first five. So let's take a look at what Donna is saying in her motion for a new trial. Now, I'm going to do this in two parts because they're two entirely different directions. One is an argument that relates to the facts that were presented to the law. The other relates to what we're going to talk about today: juror misconduct, and whether or not the jury acted properly when they Donna Adelson. So let me add that. Oh, I can't share two. Yes, I can. Never mind. Can do that. All right, let me go back to this and add it to the screen. This is Donna's motion for new trial. And we're going to be, like I said, we're going to be looking specifically today at the part about the juror misconduct. So I'm just there. It's not very many paragraphs. I'm going to go ahead and read them and we can talk about it. So in the court's preliminary instructions to the jury, the standard instruction was read. This is important. Already I'm interrupting to tell you there is something really important here. First of all, the exact words are really important here. We will get into why that's so important in this particular case to Donna's argument, but also note this is standard. This is the ordinary instruction given. It wasn't like Judge Everett gave everybody a brand new, really weird, something different, something unexpected instruction. It's a regular one. That's what Donna's team is saying. So here it is. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media, or a website, or any other form of communication. So let's keep reading the last couple of paragraphs. Subsequent to the trial, juror number 7, and it turns out she was the foreperson as well, went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. A flash drive with this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by the juror from her account. Now, we went over a little bit about what she said on TikTok in the video right before I left. That was related to Wendi. And we'll probably do a whole nother series on that as we look at what each of the jurors said about Wendi. But that will be for another day. For today, I want to talk about this flash drive and the deleted TikTok that they're talking about. So let's keep reading. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. Additionally, juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated that he, quote, obviously did not consider that during deliberations, that he considered Mrs. Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external, rather than that which inheres in the verdict. As a result, the undersigned seeks to interview juror number 7 concerning his consideration of Mrs. Adelson's reactions to the evidence. Now, I believe in that paragraph, they meant to say juror number 5 because they've already said they wanted to interview juror number 7, and because they say his. So I think that was just a typo. Say juror number 5 there. So they're asking to interview 2 jurors. We are going to look at the 3 jurors who have given interviews, what each one of them said, and whether or not there's anything in that to suggest that maybe there was misconduct, that maybe Donna Adelson might be able to use this to get a new trial. All right, so I want to talk to kind of explain this. I want to talk a little bit about the law, about what she's going to have to prove. And do not worry, we are going to get into the law, but it's not going to be heavy. It's just going to be something you can understand. We're going to talk about it. So don't worry. I just have a couple of sentences here that I want to point out. In order for Donna Adelson to get a juror interview, remember, this is not all the way to a motion for a new trial. All she's asking for right now is a juror interview. And to get that, she said, is she does not have to conclusively establish the alleged juror misconduct occurred and actually prejudiced his case or her case. And it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Once improper contact or juror misconduct is established by the juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. Okay, let's remove that and I'll make this a little bigger. So, breaking that down just to kind of simplify it, the core, what this is, the core issue is that the courts are trying to balance a couple of different things. On the one hand, they very much want to guard the privacy of the jury deliberations for a host of reasons. They are supposed to be secret, and you want jurors to serve, right? And if you hassle them with interviews or depositions afterwards, it's going to be harder to get people willing to serve. And you want the jury to be able to talk privately so that they are not influenced by anything on the outside. So you want them to be impartial. You want them to actually feel empowered to be able to pick an unpopular answer. That is a fundamental tenet of the jury system. That's super important. On the other hand, and this is what courts are having to balance, you don't want juror misconduct, because that would mean that the trial wasn't fair. And so those are the two things that are being balanced in either direction. So I want to talk a little bit about how Florida makes that decision. Now, this is not the Florida decision, the Florida standard, let me call it that, is I'm not a Florida lawyer, so I'm not giving legal advice. I just want to get into just basically what they look at. And we can pull this out of Donna's own brief here, as well as some work that I did just doing some quick review about that, just so we can understand it. All right. There are a few people. Bama Queen. What a nice note. One thing I would also like to ask, if you have already hit the like button, you will have the ability to do something called something new for YouTube, hype the video. It's kind of like a super like. I would appreciate it if you would do that. But first hit that like button. That would be a huge help, completely free, and it's a big help to the channel. So Neil has a good question for me. I will save that. And thank you, Jackie P, who has been a member for 19 months, as has Bama Queen. That's forever. That is our entire history of membership here on the channel. So thank you both so much for doing. And Breeze Coyote, thank you. Okay, so let's take a little scroll through the Florida standard for jury misconduct. So the basic question that the court is going to be asking is, did the jurors' actions interfere with a fair and impartial trial? It comes out a little funny, I think, in Florida law, not the way you might normally think of it. If the juror misconduct involved overt acts that were extrinsic to the verdict, we'll talk about that, then that might have affected the trial. But if it's matters that inhere in the verdict, it would not. So which sounds crazy. Here's essentially what they're saying. If what happened was outside the verdict, like example, and it was something outside what the jury heard and their actual deliberation. See, cone of silence drops over the jury deliberation. So if it's something from outside and an overt act, it's extrinsic to the verdict. Well, then the courts are going to say, okay, that we don't we want to avoid getting into what the jury was thinking, but this was outside what the jury was thinking. So we will consider that. On the other hand, if it's inside that cone of silence in the jury room, that's what we're not going to pay attention to, because that has to be silent. So even if the jury misunderstood something really important, then even as basic as, oh, I thought it was the car on the right that went off the road and it was the car on the left, I misunderstood that. Even if it's something big like that, if it's inside the jury deliberations, inside a juror's thoughts, that's when the courts won't look at it. So they are avoiding getting into those discussions so that they remain completely private. But here are some examples of juror misconduct that might conceivably get somebody like Donna Adelson a new trial. First would be if a juror talked to parties or to outsiders about the case. Obviously, that would be something outside what happens inside the jury verdict discussion. If the juror did extrinsic research, like they went out and did some independent research, maybe they went to the scene, maybe they brought in, like I mentioned, the textbook, something like that. Well, that's outside the jury discussion. What about a juror influence? Maybe one juror influences another in some inappropriate way, then that would still be a way to get a new trial, or at least a juror interview, and then maybe move to get a new trial. If a juror just flat out refused to deliberate, courts have said, well, that's not inside the room. That's just, they aren't even participating. Or if maybe the jury did something really crazy, like they used a game of chance. Let's say they said, we just cannot decide. Donna Adelson, guilty, not guilty. Let's roll some dice. If they did something like that, let's pull out dollar bills and look at the numbers on them, and that's how we'll decide. Then there's no deliberation that happened. So courts will say, okay, that's the sort of thing that might get somebody a new trial. Or racial bias, some kind of prejudice. Those sorts of things might get a juror interview, might get it, because they're outside the deliberations. So we're going to take that and we're going to apply it to what each of the jurors said, so we can see whether there's anything that actually could make a difference for them. Now, before we do that, I do need to give you sort of the general lay of the land here. Courts hate these motions. They do not want to retry the case. They don't want to harass the jury. It starts a case within a case, and that is the last thing they want to do. Is have, remember Murdoch's hearing where they had to bring the jurors in, and it was a big deal, right? All the media is there. It's covered. It's a new case. Courts don't want that. So Donna's team is doing something very conscious, very specific. They are not taking this head on and saying, yes, I'm already entitled to a new trial. Instead, they're only saying we want an interview. But why do they want an interview? Because they are hoping they're going to get evidence that they can then use to move for a new trial. So the judge knows this. I mean, everyone knows this. No one is going to be caught surprised by this. But the court is not going to want to grant this. This is really not what the court wants to do. And that's the backdrop as we talk about it. That's where we stand as we go into what the jurors said and what the facts are. So I have seen interviews with jurors 5, 6, and 7. 7, the foreperson, also posted some videos on her own TikTok. So let's just do a quick summary of what each of them said and talk about whether or not it fits with the idea that they did something that might be considered juror misconduct. So juror number 6, a man named Evan Higginbotham, was interviewed on Surviving the Survivor. Just 24 years old. He's a college student, and his knowledge going into the case was he vaguely heard about this murder back when he was a teen in Tallahassee, but he had paid very little attention at the time. In his view, this trial really changed his life. He literally changed his major from engineering to pre-law because this so impacted him. In general, his impression was that the prosecutors, Georgia Cappleman, Sarah Dugan, were very passionate, that they were prepared, they were impressive, they had a very strong case, and he did not feel that the defense did as much. He said they did the best possible with not having a lot to work with, but he didn't really care for the sort of folksy style that Jackie Fulford had. He just didn't believe that it was as good a presentation. Now, that's a difference in the way he saw them, right? He saw the prosecutor as really well prepared and effective, the defense not so much. But that's nothing that would undermine the verdict. That's not bias. That's just his opinion about how the sides did. That's what he's there for, is to evaluate the facts as they came out and as they were presented. So he talked about the jury deliberations as well. And everything about it sounded very deliberate, not anything that would even remotely be grounds for juror misconduct. So all 3 jurors agreed that not everyone came in agreeing completely. It sounded like they were agreed on at least the murder charge, and then they had some questions about some of the other subsidiary charges, either solicitation or conspiracy. And they answered those. They went through the evidence. They talked about that. It was very deliberate. They did multiple votes. Everyone voted. And there's nothing wrong with people coming in undecided and changing their minds. That's why you have 12 jurors. That's exactly what they are supposed to do. They're supposed to all talk about what's happened and make a decision together. Remember that if they get deadlocked and they can't make a decision, the judge will tell them, go back in there and talk about it some more. See if you maybe couldn't agree with somebody else. See if maybe you might be in the wrong. Think it over, go back. So there's nothing wrong with that particular, with the way it shook out in that regard. As far as what he thought was important evidence, he was, in fact, all 3, the jurors mentioned Rob Adelson, Donna's son, and they felt like he was very credible, very compelling. Georgia Cappleman said after the verdict came in an interview that the reason she had not used Rob Adelson before was because she just hated to put him through this, but she felt like she really needed him in this case. And clearly it was a good choice. He was obviously very effective. The jury felt like he had no motive to lie. If anything, he would have a motive to protect his family. But instead, they felt like what he said pretty much affected Donna's character, gave them insight. As far as the jailhouse informant, some of the most controversial testimony in Donna Adelson's trial came from 2 inmates who had been housed with her while she was in jail awaiting trial. And the juror, Evan Higginbotham, said he held their testimony in very low regard, just that he didn't put a lot of stock in it. He did think the handwriting evidence was very strong. It was evidence that from a handwriting expert that Donna had actually written out, it was her handwriting, a list of things that one of the jurors was supposed to go to the prosecutors and tell them. And of course, it was something that would help Donna with her case. And he said, that he didn't give them too much credibility, but there was a video of Donna writing something, and then they had this exact document with a handwriting expert saying, yeah, this is Donna's. And there was, ultimately, the defense didn't even object, that it was not her writing. He also really thought highly of the cell phone evidence that we covered during the trial, the location data, Donna being at Charlie's house on the night Dan Markel was murdered, etc. The bump operation was another important point for him because Donna's reaction when a person posing as a Latin gang member or just a gang member came up to her on the street and handed her this sheet of paper. It was an article about Dan Markel's murder. It had a phone number and $5,000 written on it. This was done by the government. It was called a bump. They were trying to pretend to extort the Adelsons. They were hoping they would get everybody talking while they now had a wiretap and they could listen to what they had to say. So he believed the fact that Donna didn't read the paper, she just tucked it away until later, and the fact that she called Charlie right away saying, this is about the two of us, and spoke in code, all of that he felt like was very damning. And then there was also the issue of the license plate note. That was a brand new piece of information that came out in this particular trial. They had, for the first time, Donna's planner. Donna's planner had, go ahead and hide the album. Just a second. Okay. Donna's planner had Dan Markel's license plate number. Didn't have Wendy's, didn't have anybody else's, just Dan Markel's license plate. The reason that was so important is because that could mean that the license plate was written down in Donna's planner because she was the one who communicated that to the two hitmen, or at least to Charlie, who communicated it to Katie, who communicated it to the two hitmen. And if that was the case, that ties Donna in with pre-planning for the murder of Dan Markel, because the hitman, the one who testified, said they were able to track his car. They knew which one it was. They had information about it. Now, that is actually one of the things that confuses this issue a little bit. I don't think it relates to juror misconduct at all. The juror was simply talking about this fact was important to him. The one place where it may actually help Donna with her appeal, though, is that this her team suggested that there were other things in that planner that might have been relevant. We don't know what they were because they only introduced a few, I think 3 or 4 maybe pages from the entire planner. And there were other things as well. If other pages had everyone else's license plate and number, that might have made a difference, but the judge wouldn't allow anything in that the state wasn't presenting. So this, in theory, could help Donna with her appeal if Donna appeals on the ground that this license plate number should have, that this was something important enough that the entire planner should have been admitted, and the trial court made a mistake in not letting that happen. The fact that a juror thought this was important might actually end up helping Donna if the appellate court agrees with her on that. He thought the one-way flight to Vietnam incredibly important, and just the whole talking in code thing, just as Georgia Kappelman argued in her closing argument, that people who talk in code, those are people who are trying to hide something, and he agreed with that. So he actually told Joel Waldman in the interview that he really tried to ignore Donna Adelson and sort of her demeanor during the trial. She was sometimes eye rolls or reactions. He tried to ignore that, to not paying attention to that. There's nothing specifically wrong with assessing Donna's demeanor. That is relevant. And in fact, her team, when you think about it, tried to put in information about her demeanor. Remember the friend who got on the stand and talked about the very day when Donna heard about Dan Markel's that he'd been shot and he died the next day. She got in the car, she's headed to Tallahassee to see Wendi, and she's talking to some of her friends. And the friend said she was very upset. She seemed very surprised. Wendi also testified that when she called her that from the jail, Donna Adelson seemed very shocked and surprised and upset. So Donna Adelson also put in evidence about her reaction to the things that happened. So taking a look at all of those facts from juror number 5, there was nothing that suggested that there was any kind of external contact or somebody doing research outside the jury room. There was no outside information that got brought in. Nobody did anything wrong with the deliberations. They didn't try to throw dice or do anything crazy like that. There was nothing suggesting that any of the jurors was biased. So the defense does not even ask to interview him. They clearly don't believe they have any hope there of getting anything. So let's move on to juror number 5. This is Mitchell McKenzie from Tallahassee, originally a 20-year Marine veteran. And he said he knew nothing about this case when he was initially seated as a juror. He watched Donna's reactions, he did say, during Rob and Wendi's testimony, but he really stressed that he did not use her demeanor against her or anything like that. So there is debate over whether or not that's fair. After all, if somebody is not testifying, then it can be kind of hard to interpret how they react to something. Do they have to cry? Do they have to have tears? Do you have to have seen the tears? It's really hard to kind of interpret sometimes without any words to go with it. And if a person chooses not to testify, in a way, looking at how they react or how they act there in the courtroom is sort of taking them as testifying in that little sense of the word. So there is some controversy over that, over whether or not that should be part of the jury thinking. I personally think it's really impossible not to consider that. And I think both sides put that sort of evidence in here. I do not think there will be anything related to that that will be used to give Donna Adelson a new trial, in my opinion. The biggest issue, I think, is that the judge told Donna Adelson, remember, that she was being too emotional. She cried through maybe the first 3 or 4 witnesses, and then he told her, you aren't allowed to do that. Let's see what they wrote in the brief about that. It's down a ways. Got it marked for you. Okay, the court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. I think that's funny, prior to the reading of the verdict, because we all remember what happened when after the verdict. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out. She did not need tissues to wipe away her tears. Sorry, she did need tissues, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. This impacted the decision of the jury, resulting in Ms. Adelson not receiving a fair trial. So what they're arguing is that the court telling Donna Adelson, don't cry, don't show any emotion, that's the kind of thing that the jury might use against her, and it wasn't fair. And so a few little comments like this will have something to do with that. They will argue, look, they were looking at her demeanor. They even say they were looking at her demeanor. So for the judge to artificially insert himself in it and tell her what that demeanor had to be was inappropriate and could have influenced the way the jury felt about her. We think about, say, Brian Koberger. In Brian Koberger's case, the defense moved to let the jury know about his mental health issues, including autism, because they felt like his sort of cold and robotic appearance during trial, if it had gone that far, that might influence the jury, that they might find themselves thinking, wow, there's something wrong with him. He seems like a murderer. And so they're saying that there was some issue around that. So like the first witness, he really believed strongly in the cell phone data. That was really important to him. The maps that were done, and that were done much more effectively by the state this time than I think even in Charlie's trial. He liked Rob Adelson. He was impacted by the video of Donna writing at a table in jail, and then by the presentation in Donna's own handwriting of a script that was supposed to be used by her jail inmate friend who was supposedly going to testify for Donna. And the state was saying Donna was trying to basically bribe these people to testify falsely. But the state offered, they wanted something else. They took that to the state and said, how about we negotiate for some kind of immunity or reduced sentence? He also believed that code talk between Charlie and Donna was highly suspicious. Innocent people don't talk in code. This was a quote, I think, from Georgia Kappelman. He believed that fact about the wet money that we talked about, that came from Katie Madbanawa, who was Charlie's girlfriend and hired the hitmen. Katie Madbanawa talked about how the money she received and then passed on to the hitman, that it was wet, and that Charlie told her his mother had washed it, literally washed it in the washing machine, and that's why it was wet. He thought that was an important fact. He also thought the way Donna acted during the bump just made her look very guilty. There were a couple of new things he pointed out. First, he was struck by the fact that Donna offered prescription drugs to a recovering addict. That was one of the ways she was going to bribe the two inmates she was trying to get to testify on her behalf. And those prescription drugs presumably would have been something that might have hurt the inmates. Now, there wasn't a lot of testimony about that, but he sort of took that as character evidence. This tells me something about her character, that she would, to benefit herself, throw drugs at someone who's an addict and in recovery. So evidence of somebody's bad character is not allowed. So you aren't allowed to just put in, well, this is a bad person, so obviously they murdered Dan Markel, because those two things don't fit together. You could be a bad person and still not have murdered Dan Markel. And so, but I think that, again, this is, to me, that's pretty much internal thinking about, he was thinking to himself, the prescription drugs, what does that tell me about Donna Adelson? So I don't think that will have any relevance to a decision about whether or not the Donna Adelson team is going to get a jury interview or a new trial. There was one other fact he mentioned, which was that the jury had wanted to play back, rewatch, he called it, the Rivera testimony. I was surprised that they maybe had the testimony back there with them. I didn't understand they literally had all the testimony. They may have meant some of the interviews. I don't know exactly what they meant, but they weren't able to get it to play. And so as a result, they just decided, okay, they ended up not looking at it. They did look at exhibits and at other things, but they did not rewatch the Rivera testimony. Again, I would say that's pretty small. Now, you could argue, Donna's team can argue, well, that's extrinsic. That's just an inability to access evidence. That's not something where it's a thought. It's not the jury deliberations. But there isn't really any evidence that the jury thought it was all that important. If they had, Obviously, they could ask the court or the bailiff, hey, can you help us with this? We're having a hard time getting this to play. They didn't even bother to do that. That makes it seem more like this was really, frankly, unimportant to them, not that big a deal. Now, this juror also said that after about day 4 or 5, he was pretty certain about how he felt about Donna Adelson's guilt, but he tried to keep an open mind, said they did not do any deliberations until they got all the way to the end. And while ideally anyone from the defense side is going to say before the trial gets started and is going to remind the jury at the end of the case, don't make up your mind until you've heard everything. Wait until we speak before you make up your mind. Nonetheless, this is very common to humans, is that when you get a certain quantity of evidence, you start to think, I think I know what happened here. I feel confident about it. And that's what happened here. There's nothing really odd or abnormal about that. Now, I wanted to play just a little bit of the testimony he had. Let's add him up. I wanted you to hear kind of what he had to say about how they made their deliberations, because I felt like it was really strong. It was very careful. It was very considered. And so I thought this is something you would want to hear.
Way more comfortable. Like I said, I think I was the only one that voiced a specific concern, and I think it was on count 3, the solicitation, and it was like the second bullet point. I don't want to get into too much detail about specifically fair. What it is, but there was something just in the way I was reading it. And as we were talking about it, I asked everyone, I said, just give me a few minutes and let me read through some of the jury instructions and maybe refer back to a piece of evidence or two, and just give me a moment. And so they did. Everybody respected that boundary, and they gave me a few minutes, and I went through and I kind of seen what I was reading. I was, things become a little more clear for me. I was like, okay, I'm good to go. I feel good about where I'm at. And so then the foreperson also, she did kind of an anonymous ballot type thing where she passed around some blank paper, and we were all able to write where we stood, overall, after we kind of went count by count and bullet point by bullet point, to kind of take away, I guess, the pressure that some of these folks might have had to follow along with what everybody else was saying. And,
did you vote each time you hit a point in each of the charges, or did you vote on each charge? How did you do that?
So we voted each point under each charge verbally. And if everybody wasn't a solid yes, and it wasn't even, again, this jury was so good and so professional and so locked in on what we were there to do. If anyone even, count 1 bullet point 1, if it's yes, yes, if there was the slightest hesitation, we stopped. And we addressed what that hesitation was caused from, and we went back, and everybody at the end of the day was a solid. I mean, that once we got to the final decision, before we wrapped up and did anything official, we went around the room again to say, hey, now is the time. If there are any concerns, any questions, any doubts, let's address them. And go ahead. I'm sorry.
No. I apologize. What about is there a moment in the deliberations room or multiple moments where you realize the heaviness of the decision you're making, that you're going to either let a woman free who could be guilty or put someone away who is guilty for the rest of their natural, in Florida, life is life. So what about the weightiness of this decision? Does that cross your mind?
Oh, it absolutely does. And we talked about that. I mean,
So I was, and again, that is from Surviving the Survivor, a friend channel of ours. And that one of the things that I think about when I hear him describing what they did and how they deliberated, it seems really well done. They made sure that everyone was in agreement. They talked about things. They were patient. They were deliberate. It sounds like the deliberations were well done. So let's, again, evaluate those juror misconduct factors that we talked about. There weren't any premature discussions. Nobody brought in outside research or media. They didn't do anything beforehand. He specifically said at one point that he had stayed offline. The deliberations were very careful. They complied with all of the court's instructions. Overall, it seems to me they did an excellent job doing this. Now, looking at the two things that I think are kind of left are that issue about the fact that he watched Donna Adelson's demeanor. I don't think there's anything wrong with that, in my opinion, and that they were unable to rewatch Rivera testimony. So far, I think everything we've seen is very small. I don't think there's enough, even close, for Donna to be able to get a juror interview or, even more importantly, a new trial from this. But now we hit the part that is the most worrisome, the part that Donna Adelson herself is focused on, and that is the TikToks that the four-person juror 7 made on her own. Now, we are apparently missing something that she made during the course of trial, and that, according to Donna's team, has been deleted from her TikTok. We know that they exist because she references them. So I want to divide this into two parts. I want to talk first about what she said when she was interviewed by another channel, Mentor Lawyer, and when she went on that channel, what she talked about. Then I want to take a look at the TikToks that are available and talk about whether or not this is going to be a problem. Is this something that might lead to Donna Adelson being able to get an interview of Juror 7 and maybe even be able to get a new trial? So we're going to divide it into those two parts. So let's talk about initially what she said. She said that the jury very much tried to focus on the fact that this was Donna Adelson's trial. It wasn't Wendi's trial. It wasn't Charlie's trial. It was Donna's trial. And to focus on the evidence that was admitted in this case. She said she gave some opinions publicly after the trial, but they were based on the trial evidence because that's what she knew. That's what she had. Now, as she thought several things from Wendi's testimony were particularly important. One was kind of her odd behavior, things like taking a picture at the beach with Katie Medbanwa, and they supposedly had only met twice. And here they were at the beach together, taking a picture together. She thought that was odd. She also thought it was odd that Wendi had apparently concealed her boyfriend, Jeff Lacoste, from her family, which made no sense. Jeffrey Lacoste had been to her house while her mother, Donna Adelson, was there. She said she believed Wendi was guilty in some way, but she couldn't really pinpoint exactly what the charges would be. She wasn't sure that they would be as strong, as serious as what Donna Adelson was charged with. With Luis Rivera, she said she would not rely on him for major truth, but she did think that the main point that Luis Rivera and that Sigfredo Garcia did the hit, that came through loud and clear. She bought that from him. That made sense. Now, the defense had what they thought was a really bombshell piece of evidence that happened during Luis Rivera's deposition. They showed him a graphic of all the people involved and got him to say Charlie was involved and Katie was involved and Sigfredo was involved and Wendi was involved. But he put an X by Donna and by Harvey because he didn't know. But the witness said that didn't really seem like a fair conclusion to her because, after all, this was a guy who was intentionally downstream. He wasn't interacting with Donna and Harvey. So the fact that he didn't know about them didn't really carry much weight with this particular juror. Like the other, she was very impressed with Rob Adelson. She said it had a real emotional impact with the jury as they realized how estranged he was for a long time from his family. And she also was really struck by a detail that Donna told Rob Adelson, according to Rob's testimony, that she said that the killers had knocked on the window of Dan's car and asked, "Are you Dan?" and then shot him. And Rob thought, how would anyone know that? I mean, the hitmen haven't been caught as of this time. And it was years before they actually put anybody in jail related to that or associated the two hitmen with this. So there was no one in jail for this. And then Dan Markel was immediately rendered unable to communicate. He never spoke again. And how did anyone know? How would Donna have known that someone knocked on the window and said, "Are you Dan?" and then shot, unless she had some kind of extrinsic information? They were, as far as Professor Jeffrey Lacasse, Wendy's boyfriend, about the time of the murder of Dan Markel, she had kind of mixed reviews about how she felt about Jeffrey Lacasse. On the one hand, she was really concerned about why, if Wendi really told him that Charlie actually had said he might hire a hitman, why would he not have taken that to the police right away? It just seemed so enmeshed with Wendi that there was some question in her mind. That she was impressed by Charlie's ex-girlfriend, June Umchinda, saying that Donna told her that Dan was haunting her from the grave. She was also impressed by the witnesses who talked about Donna's very intense hatred of Dan Markel and about the checks that Donna wrote to Katie Medvanwa, even though Katie wasn't an employee. So with Katie Medvanwa, she said, frankly, it was probably partial truth that you got from Katie, and it was pretty hard to separate out which parts were true and which were not, which I think is a fair assessment. That she was really hard to trust based on how many different stories she told across her interviews and her trial testimonies. The bump, she was also impressed by the two of us and Donna's conversation with Charlie right after the bump occurred. So given what we've heard from this interview, is there any juror misconduct in that? What we've got, again, there's no external contact or research coming into the jury room. There's no discussion of outside information. It's a legitimate look at in-court evidence. Nobody refused to deliberate. They didn't cast lots or do something weird inside the jury room. No one showed any prejudice. So nothing in here strikes me as having any bearing on a motion for a new trial or as entitling them to a juror interview. There was some discussion about body language and demeanor. We've already covered that. I think that's legitimate. I just don't see a lot of hope for them. So we are now down to the last point. And this is the number one thing that Donna's team is talking about. At least they mention it specifically. And that is the Tik Toks that she made, and specifically one that apparently was deleted that she made during the course of the trial when she said she had been selected as a juror. So it sounded like that basically she just told people, hey, I'm on a jury. This is really exciting. And it may have been an absolute nothing. Should she have done that? Probably not. Let's sort of analyze this and see what we think about it as we take a look at it. So what I want to do is show you a brief excerpt from her Tik Tok where she talks about this specifically. So let's add that to the stage.
Being selected to serve on the jury, okay? First and foremost. Number two, as far as people's concerns as to me being on social media and posting my TikToks in the last week or two, there was no rule stating that we cannot be on social media. The rule is provided by Judge Everett in this case, okay? We cannot seek out information about this case. We cannot talk about the case with anyone. We cannot listen to others talk about the case. We cannot do anything in regard to the case during the trial. But now that I'm released as a juror, I have the freedom to say and do whatever. But also in that regard, I don't watch the news. It's depressing. I haven't watched the news in years. If anything, I'll check my weather app, my little Apple weather app once a week just to see. My For You page on my TikTok, where I am the most active, is mostly like TikTok shop videos, like members of like the moms of TikTok community, because that is the content that I typically engage and interact with. I also post that type of content sometimes, just like trendy, funny, like music videos, whatever else like that. Basically like stupid humor and then mom stuff. That's what I look for on social media. So I'm not breaking any rules. Along with that, I have time before court, during our 1 hour, at least minimum, lunch break during the days of the trial, and then after court to do as I will in regard to to all of that. So no rules were broken. No rules are being broken now. I appreciate all of your guys' concern.
Okay, so what she says is that what she did was allowed by Judge Everett. So I want to take a look at what the actual instruction was. So here is what Judge Everett said. We talked about it at the beginning. I want to read it one more time. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media or a website, or any other form of communication. So what that's saying is you can't communicate about the case, including by posting information on social media. So I think she's absolutely right that during the lunch break, she could be on TikTok. I don't think that was forbidden as long as she wasn't communicating about this case. But anything about the case on social media, I think, did violate what the court was telling the jury to do. So even just an excited post, like, I'm so glad to be on social media, anything that they did that was about the case. Such as, I'm so glad to be on this case. What couldn't happen was communication about the case. Now, it would be particularly problematic if she said anything specific about the case and if there were comments from outsiders about the case to her. Now, she does seem, based on her TikTok, as you listen to it, she's very responsive to comments. I would say even defensive about them. So if she responded to anyone, that would be communication. So on the other hand, everything she did says she was trying to approach the case with absolute integrity. Her dealing with the jury as a foreperson was well beyond her actual, it's what you might expect of someone as young as she is. She was phenomenal. She corralled everybody just exactly right. She made sure everybody correctly understood. She was a phenomenal jury foreperson. On the other hand, I do think if she posted on TikTok about the case, that was a violation of what the court told them to do. So, okay, what's going to happen here, right? This is kind of how I analyze it. Personally, I do think that it's a direct problem if that happened. I personally would, if I were king of the world, judge of this case, I would allow at least a juror interview to just find out what exactly got posted and whether there were any comments and whether there was any response from her in the comments. So I would at least allow that interview, a hearing on that, Donna's ability to present and say this was or wasn't. Now, let me tell you, though, what my prediction about what is going to happen here. The court is not going to want anything to do with this. The court is not going to want to do that. Judge Everett is very unlikely to allow interviews, in my opinion. He is going to look at this and say, look, there is no evidence that there was any material breach of the order. There's no evidence that she spoke to people, anything other than made a generic post, hey, glad to be a juror. So my guess is that he will shut this down, but that it will raise its head again on appeal. That I do think there will be issues around this when it comes time for an appeal. So that's, let's go ahead and take some questions. If you would put question marks at the beginning of your question, I would appreciate that. And I already have some over here in the super chat. So let me get started on those. Neil Morrison, Bill Slim's fan club. So before I start, sorry that I'm only now getting to it. The defense attorneys have taken a bit of criticism. How would a defendant know who is a good attorney? You know, that is a really hard question to answer, and it matters so much. I think the person you hire to defend you or represent you is critically important. It makes a huge difference. The best thing you can do, I think, is get the opinions of other people who know that person in a professional setting. In other words, other lawyers, and what they think about the person, and do they think that person would do a good job for you. Now, in this case, I personally felt like the attorneys, I thought Jackie Fulford did an excellent job. I thought her closing argument was excellent. And I felt like she did a good job throughout the case. This was a hard case to defend. And you have to remember the sheer statistics of it all, that there are going to be 98% of the people are going to lose at trial, of the defendants are going to lose at trial. So to a large extent, this is ultimately not something that the person can affect, as long as you have someone doing the absolute best job for you that they possibly can, going out, looking for evidence, all of that. It's a hard question and a really important one. So I wish I had a more specific answer for you, but it is important. Pascaline having a question: is it an appeal or a completely different rule of law asking for a new trial? So Pascaline, this is actually before we even get to the appeal. So there are multiple layers. At this stage, what they are still in the trial court, and Donna's team is saying, we would like a new trial. Start over again. Don't bother with that appeal. We shouldn't have even been convicted. Let's just start over again. Start the whole process over again, brand new trial. At least give us some juror interviews, and then we're going to move for the brand new trial. They've already asked for the brand new trial on some other grounds, but they do plan in the future to ask for it with the juror misconduct if they can compile enough evidence to do that. So this will all happen in the trial court and would just be a decision about a new trial. I am predicting now the judge is going to deny this. But after that's done, after Donna is sentenced, then comes the appeal. And that will be to a different court, an appellate court, and they will make a decision on whatever grounds Donna Adelson's team brings. It won't be everything they argued about during the trial. It'll just be some specific grounds. Nishay wants to know if 41 is too old to even think about law school. I don't think so. I don't think so at all. I think you definitely could still think about that if it interests you. It's a super interesting career, that's for sure. And I do understand 3 years is a long time, right? That's a huge commitment. There is a school here in my community where they let you do it at night while you're working, and it takes about 4 years, a little bit longer. You take fewer classes at a time, but you get it done over time. So that might be an option too, if that really interests you. I know that stretches us out a little bit, but it makes it a little more compatible with life at the same time. Okay, let me head over and see if there are some question marks at the beginning. Okay, here we go. KCL thought that juror number 7, who posted on TikTok, did not say anything about being on a jury or anything about the case until after the trial was over. So it's a question, right? What exactly was said? Now, what Donna Adelson's team has said is that there was something that got posted during the trial and that it's been deleted. You could also take that, I think, from what she said in her own TikTok. She said, as to me being on social media and personed, I have that word wrong, by TikToks in the last week or two, there was no rule stating we cannot be on social media. So I think that it sounds like she was on social media. If she was talking about the case, that's what Judge Everett had said don't do. Now, if all she said was, hey, I'm on a jury, this is really cool, I've never been on a jury before, there is no way, I think, that any court is going to find that that was a violation significant enough to affect the case. If what she said was something more than that, if people made comments to her that she read about the case, about what they thought about guilt or innocence, then maybe the bets are back on for Donna Adelson. What exactly was said there, that's why I personally would give them the juror interview just to find out what exactly was said, if she knows, if she has any evidence about that, if it's been deleted, those kinds of questions. So if I were in charge, I would let there be an interview, but I don't think the court will. And even if there is an interview, that doesn't mean it rises to the level of juror misconduct that merits a new trial. Very unlikely. That would be my thought on it. Liberty Lisa, can jurors be found in contempt of court if they go against the judge's orders? They could. There is no way they're going to find this juror in contempt of court. I mean, she did such a good job in so many ways and was an exemplary foreperson. So I cannot imagine that happening. Just my opinion. Elizabeth wanting to know, is there enough evidence to prosecute Wendi or Harvey? You know, I think I'm going to do a whole separate video on that related to what exactly the people who were there, the jurors, thought about that and what they said about Wendi and Harvey, because I think that's awfully interesting. Hey, Mona wants to know, is this timing of these motions before sentencing unusual? Not really. I wouldn't say it. If they had done what the judge planned to do, which is go ahead and do the sentencing right then and there, because it's mandatory that she get life in prison. If they'd done that, then it would be in a different order, right? Just like you're saying, the sentencing would have happened and then the motion. But in many courts, they hold that out, stretch that out over a period of time. So I don't think that's necessarily shocking, just the way it worked out. The defense asked for an extension. They said, we need to deal with our client who's really upset. Let us deal with that. Let's don't do sentencing today. It's not going to make any difference. She's going to get life in prison. So they don't even have a choice. That is definitely what's going to happen. So Sal wants to know, how do you feel now it's over? Is there anything you noticed after evidence-wise that was missed by the defense at the time, which they could have capitalized on? Sal, my number one thing is I do not feel that Katie Medbanua was cross-examined even close to thoroughly, because Katie has a ton of baggage from her numerous different stories that she told in the course of police interviews, in the course of testifying in her own trials, in Charlie's trial, multiple different stories. And she told a brand new one in Donna's trial. So I feel like I would have done more with that. That would be the number one thing. But let me also say that's almost so unfair, really, because that is Monday morning quarterbacking to an extreme level, right? These lawyers were steeped in the case. They were there. They were in the middle of the battle. How easy is it to sit back and say, oh, well, I would have done this and that. I overall felt like they did a great job. I did not feel like they messed up or were problems at all. Just my, just my opinion. Tart with a Heart is thinking about enrolling in a paralegal degree. Well, that would be interesting. That would be a super interesting thing to do. I'm looking for more, question marks at the beginning. That will show me. There's some new thing they're doing where I'm supposed to be able to see question marks, but I'm not seeing them. So anyway, I'm just having to look for yours like I normally do, despite the fact there's supposed to be some new thing about it. Have I answered everybody? I don't think so, but don't forget. Well, maybe I have. Okay. All right. I think I've answered most of your questions. Well, next week we will be back on schedule. We will be doing our Monday, Wednesday, Friday at 7 p.m. Eastern, and with occasional extra bonus stuff here and there. As far as what I want to cover next, here's what I'm thinking. I am so interested in the Corey Richens trial. We have some new information in Brooks Hout's case. He's been sentenced now. So both of those are interesting. I'm very interested in the Shanna Gardner case. There's so many. If you have one you're particularly interested in, let me know. I also am very interested in Tyler Robinson's case. He's the one who shot Charlie Kirk, and I'm interested in what's being done there and how that's being handled going forward. Let me know the cases you're following or that you want to follow, though. I would really appreciate that. I always like getting your input on that. So I will see you all in the next video. Well, let's see.